miss some part of the dictation, they go back to the live stream and
that helps them.
it helps. We started this, we asked them to use their recording devices in the phone to record our orders.
Huh. Last order. Last order. Last order.
Yes, next.
Lord, in this case, Lord, the de facto complainant had named 3 persons in the FIR for which 302 cases started. These 3 persons were not charge sheeted. They were not charge sheeted. A set of people were made accused. I am one of the accused. 4 years, 4 months in custody. All that lot comes against me is because she did not name me in the FIR. She does not know me. She came as PW1. She did not identify me. She could identify only one whom she has identified. That is not me. All that I am connected with. But one of the co-accused, Saddam, alias Ma Qasam, has stated to the IO, which the IO says that I have bought a mobile phone given to me from the money by my client. And that mobile phone has been bought by Saddam because I have given the money. The IO uses the word supari. That connects me and nothing else. Rest of the and then Lord, they show a recovery of under Section 27 from a public place. This is all that is.
The initial case was started by the wife of the deceased on the assumption that previously some persons had threatened her husband, he might be responsible. Now, during the course of the investigation, it appears that one Shakuntala Jadhav and her 2 sons have a hotel. They wanted to have the adjacent plot grabbed, but this deceased Dilip Ram helped the original owner in getting that property and they stood against Shakuntala. Shakuntala had hired the petitioner before your lordships to arrange the hired killers. And there is telephonic conversation between the hired killers and the petitioners immediately before the incident. My lord, so
This
far
is
as the
what we are
hired
saying.
killers are
The
concerned,
telephonic conversation per se, it is very difficult to infer a case of
well, totally a
conspiracy.
person of different locality is being contacted, and those persons of the outside the state, they come and commit the murder, and the murderers are identified by 3 eyewitnesses. But he had no reason whatsoever to call them.
Lord, just because they are involved in murder, I have had a conversation. Lord, your lordship,
all the witnesses has been examined because he had made a prayer for deferring the cross-examination of the 2 IOs. That is going on.
Oh,
no, he has not turned up on the last day. Last day was on the 5th. The IO is not.
right.
Lordship will,
Give us some time, we will.
Lordship will kindly look into the evidence of the IO that has come.
Petitioner is in custody for 4.5 years. He submits there is no evidence.
Lord, and there is no tampering issue also now. Not that the IO is only there.
It's not a case of tampering now. It's a question of your being present when, if at all you are.
No, I'm not. I was not present. It's not their case.
We are saying present in the court
Yes.
to face the sentence if you are convicted. It's a life imprisonment case.
Then I will be there if I am granted.
Who will be there? Someone will substitute as the
No,
convict.
no.
Then
I will be there if I am granted bail.
we cannot assure in such a situation. Absolutely.
No, this is at the fag end of the trial.
Correct.
They cannot even say that I will tamper with
exactly why at the fag end of the trial we do not choose to grant bail. Because
No, nothing relates to.
It's about to end in an acquittal or a conviction. So we have to ensure the presence of the convict for the purpose
Your lordships had earlier passed 2 orders asking the trial court to complete the trial within a certain period. That also has not been done. This time at least.
We cannot do it because of the Supreme Court's direction. No? Can we say that within so and so date finish the trial? No.
No.
We'll get an assurance from the public prosecutor.
Time frame, not
time frame, but the Supreme Court discourages the time frame, right? In the last constitution bench in setting aside issue resurfacing. So we'll get a assurance from the public prosecutor with regard to completion of trial with the examination of his witnesses within 3 months.
The IOs will be present in the
Right.
next dates.
When is the next date?
13th of this month.
Okay, we adjourn this up to 13th.
Lordship,
Right?
15th to 14th of 15th.
We'll keep it 1 week after that.
Lordship.
He prays for bail. Learned public prosecutor submits. Cross-examination of the investigating officers are in progress. Date has been fixed on 13th of March 2024. Under such circumstances, we request the trial court to conclude the examination of the investigating officers on the aforesaid date, and if it is unable to do so positively within a fortnight thereof. Full stop. Let this matter appear on 4th of April 2024. Further report be filed on that day. By that time, if your evidence is complete, finished. 8th of April. 8th of April. Next.
Lordship.
Implicating him in the crime. Yes, next matter.
Well, this is my application. Lord, last occasion your lordship asked me to prepare a chart. This is a default bail, my lord.
Yes.
This is the chart, my lord. এটা একটু দিয়ে দিন না।
This is my paper.
But initially, the case was started under section 489B and C. But although there is no provision for extension, so far as the IPC offences are concerned, the IO prayed for extension. This is number one. Then, my lord, on 13(9), the sub-inspector of police, he gave a prayer so far as addition of section 15 of the UAPA Act.
But did you apply for bail?
Yes, my lord, I applied for bail.
When did you apply?
My lord, I applied for bail on, my lord, kindly see, on 14th.
14/9/2000.
That was turned.
Correct. By that time, there was a prayer for UAP.
Yes, my lord, IO has given, my lord, the sub-inspector has given. This is not, my lord, the permissible under the law.
Yeah.
Yes, my lord, kindly see, my lord, this investigation of high quality counterfeit currency rules, my lord, 2013, it says it has to by the superintendent of police. If it is relates to, my lord, the forgery, my lord, the currency. Lord, both the order addition of UAPA Act and, my lord, the prayer given by the IO was set aside by the Sessions Court. My lord, till then, once the file record is placed before the, my lord, this our Bichar Bhavan, and then again it was sent back. Bichar Bhavan says that we don't have any jurisdiction, so let it be sent back to the Murshidabad. And the case record from there, my lord, sent to the High Court. My lord, it is pending now. The reference is pending. Which court has the jurisdiction?
For what?
For try the offences, my lord. Because Bichar Bhavan says only NIA cases we have the jurisdiction to try. But state cases, the Bichar Bhavan doesn't have the power to try those offences.
Right.
Now again they send
But,
back the file.
where is the superintendent of police's power?
But I have marked it. My lord,
Now
kindly
we have seen it will be referred to the superintendent of police.
yes.
When if such officer is satisfied that the amount of the he may order apply. So the investigating officer may apply. He must obtain a sanction or an order from the superintendent of police.
That has been done. Kindly see.
Then it's not that the superintendent of police has to make an application. He gets a sanction from the superintendent and then proceeds on
That
his
is true,
own.
my lord. And
So
second part is IO, whether IO can apply his
yes,
mind or
why not? If the IO gets a sanction from the superintendent, then the IO can do it.
my lord, second part is, my lord, 3 years he is in custody, and my lord, which court will try the offence that has not been decided and a reference is pending before the High Court. My lord, kindly,
The reference and dispose it off.
my lord, we have not sent it. It is the district judge who has sent it.
Correct. We will look into the reference. Which court is going to try? If it's not an NIA case,
Yes.
it will be tried by the special court.
My lord, kindly see the once, my lord, kindly see the observation made by the Sessions Court once, my lord. Kindly see it, my lord. It will appear in page, my lord, 30. Sorry, my lord, not 30. Sessions Court. My lord, 22 onwards, my lord.
UAPA Act,
Yes.
section 45, I think,
41.
provides for two sets of courts. One court set up by the central government for NIA cases. Another court, which will be a special court set up by the state government. If the state government does not set up, the Court of Sessions will try.
And that too, in this case, the
We
90th,
have delivered a judgment.
I have to go through it. And that too, my
Please go through that judgment and come back. The session judge
shall come
perhaps
back.
is not aware of that.
lordship. And my lord, so far as my application is concerned, I filed the statutory bail on 19. My lord, first I filed the application.
We will
Subsequently, the investigating officer, my lord, he, after when I was supposed to released on bail, then he filed my lord, the addition of section. That was kept pending. That was not even allowed. After 2 days, that application was allowed. My lord, I have made all
the application was filed
yes.
before your application for statutory bail. 13th was their application, 14th.
14th is, my lord, and the prayer was allowed on 16th. My lord, kindly see that, my lord.
Correct. So the prayer will relate back to the day on which the prayer is made, isn't it? If someone makes a prayer for
That
addition
your
of
lordship, in
section-
that reference, your lordship is already in
Right.
APS Act, that your lordship
No,
is-
reference is a different situation, Mr. You may argue notwithstanding the reference, because in the reference the situation is like this. If a person has not applied for statutory bail and there is a prayer for extension already made, then his right does not crystallize. Here is a situation, his right had crystallized. However, after that, there is a prayer for addition of section. Even if, let us say, you were granted statutory bail, he could have rearrested you in terms of Pradeep Ram.
Yes.
You understand?
What sections they can.
What happened in Pradeep Ram? Man was in bail. Section under UAPA was added. He was rearrested. Question went to the Supreme Court. Supreme Court says, no, not,
It's a graver offense.
not necessary. Additional offenses made out,
Made out.
he has arrested. So either way, look at the two situations. Either way, your continuation of detention cannot be said to be illegal. But we will look into your issues. It's very interesting issue that you have raised. We'll look into this, but also we will have the reference before us.
Lordship.
We'll
Let's kindly
dispose of
make
the
it-
reference
yes,
also,
we'll address
because
for-
unnecessarily,
keep this matter
let us for argument's sake, we
next
don't agree with you for bail. Although we'll also consider your bail on the angle of delay, because you already undergone 3 years.
3 years.
Even if this offense is added, how much is the maximum sentence in these cases?
My lord, this it says, my lord, it's a life imprisonment.
May
UAPA,
extend to life or life.
UAPA.
Please check out all of
I shall,
those
my lord,
things.
keep the matter next week any day. My lord,
We'll keep
Tuesday,
it.
Wednesday, any
You
day.
give us the reference.
Yes, my lord, I will give it the reference. It is mentioned in the order.
Mr. Mojumdar contends that his client is entitled to statutory bail. He also submits, due to a reference made by the learned sessions judge with
SRCR 1 of 2020.
due to a reference made by the sessions court with regard to forum of trial being so and so, his trial is stalled. In light of the aforesaid submission, we give liberty to the petitioner to make prayer before the Honorable the Chief Justice on administrative side to assign for an assignment of the reference.
Gotcha.
Full stop. Matter is adjourned
2 weeks.
2 weeks. 2 weeks. In the meantime, please approach
shall do
the
it.
Honorable the Chief Justice for a for assignment. We'll take up both the
Lordship,
matters
lordship.
together.
That will be better for me also.
Exactly. We just keep your plan B. That if we don't agree with you on statutory
trial
bail,
can be started.
at least we can consider a time frame for conclusion of the trial assigning. First blush impression, Mr. Mujumdar, the sessions judge is not right. Because it's not an NIA case and the Chief Judge court is right. If it is not an NIA court, then the NIA court will not try UAPA cases. In the absence of the special court, it will be the sessions judge. Please go through it. This was a bail application which was argued by Mr. Subhashish Rai, unfortunately no longer with us. In that
Go through it.
case, we had dealt with this issue.
I shall go through it.
Even it was rejected by the Honorable Supreme Court.
When was it rejected, Mr.?
By the Honorable Supreme Court.
Hmm?
I have annexed the order, not if you kindly look into the order.
So
It was rejected on. No, taken on last time. Rejected on 13th of December 2023.
13th of December 2023.
Page 20 of the bail application. Until date, no witness has been examined.
Why no witnesses is examined?
Nobody turned up, not if you looks at.
see the case diary has been sent to this board.
Okay, that is the thing. Anyhow, তিনটে কপি থাকে।
What is the evidence against them?
Will Lordship kindly see your Lordship's last rejection order at page 9.
No, that
Petitioner
you are
is in
right.
custody for more than a year. He submits there is no progress in trial. He prays for bail. Learned lawyer for the state opposes the bail prayer. He contends bail prayer was rejected earlier. Bail prayer was rejected earlier by this court as well as the Honorable
Supreme Court.
Supreme Court. We have considered the materials on what is the statements against them?
116, the injured state.
যেটা আছে। That is there. 9% are on bail. আমি বলে দিয়েছি। Some have been granted bail, some have been granted anticipatory bail.
It is linked to state.
That is true.
Materials on record. Statements of witnesses implicate the petitioner and co-accused. Co-accused are on bail. Full stop. Bail prayer of the petitioner was rejected earlier on the ground that he absconded. Thereafter, he is in custody. Thereafter, he is
16 months.
for more than a year and trial has not commenced. Full stop. Delay in the matter cannot be attributed to the petitioner or any other petitioner. Full stop. There is no chance of under such circumstances we are inclined to enlarge the petitioner on bail 10,000 to surety.
Grateful to that.
Next. Next.
My lord, I am for the petitioner, my lord.
20, my lord has called for a case diary of a counter case. The case diary, wrong case diary has come.
Not today.
Monday.
Monday. Next.
My lord, I am for the petitioner. My lord, 300 to 394, 6 years and 4 months I am in custody. And my lord, I am renewing my prayer for bail after 3 years. My lord, 3 years ago, when your lordships rejected, the submission made was that 2 witnesses have been examined out of 59. As on date, the stage is 4 witnesses have been examined out of 59. So, my lord, in last 3 years, the progress is 2 witnesses. 6 years, 4 months, I am in custody.
You are the adult person.
I am the adult person.
Election, the trial of the
Both the cases are same court.
other before this, when there are indeed charge sheet, 51 witnesses,
59.
59 with
What is the nature of evidence, Mr. Patel?
my lord, your lordship, we have been identified in the PI record also.
Those witnesses have been examined. Who are those witnesses?
My lord, investigating officer says it will not be 51. Your lordship can record the submission, there will be more 25 witnesses examined.
Correct. Petitioner is in custody for more than 6 years. Submits there is inordinate delay in trial. He prays for bail. Learned lawyer for the
12th
state,
of March.
learned public prosecutor opposes the bail prayer. He submits. Trial was delayed as proceedings were as one of the accused was a child in conflict with law, and proceedings were uh, proceedings were continuing in different fora. Full stop. We have considered the materials on record pursuant to direction given by this court. The proceedings against the petitioner and the CCL have been transferred to the same court and are being tried independently, one after another. 5 witnesses have already been examined.
4.
4 or 5?
4, 5. Oh, 5th is going on.
4 witnesses have already been examined. 5th witness is being has already been examined, and PW5 examination of PW5 is in progress. Public prosecutor assures this court that prosecution shall streamline the number of witnesses to 25 and to 25 more witnesses and conclude examination of the witnesses within 18 months from the next date fixed before the court, subject to cooperation on behalf of the defense and other systemic delays. Full stop. In materials on record, next paragraph, materials on record show petitioner was identified by eyewitnesses during TI parade. Offense, if proved, would attract mandatory life imprisonment. Under such in view of the gravity of the offense and in light of the assurance given on behalf of the prosecution to conclude examination of witnesses within 18 months, we are not inclined to grant bail at this stage. We request the trial court to expedite the trial. Parties shall cooperate with the trial court in this regard. Next.
My lord, subject to correction, your lordships have already given a direction to conclude it within a year.
When?
My lord, at page 45, your lordship gave that in respect of the CCL who was before your lordships on 1st of May 2023, your lordship directed it to be concluded within a year.
So that's for the CCL, not for you.
Very good.
CCL different footing.
That's true.
He won't get life imprisonment.
That is true.
We'll ask the public prosecutor what sentence he will propose. See now what happens in the adult cases. Law says no death, no life. If you procure conviction under 302, what the trial judge gives? Invents a sentence. Then in a given case, you will have to answer this. What happens, Mr. Chatterjee?
Wonderful.
Because JJ Act now, you have segregated persons who are juvenile, fine, goes to the board. Person who is treated juvenile CCL but treated as adult by the children's court.
Yeah.
So that they can be imposed any sentence except life or death. Law prescribes only life or death as sentence. What happens?
Option.
Think about it. This problem
will come up in some
has to come up.
research.
The trial judge has to address it. Once Mr. Rai convicts the case, if he procures conviction, in this case itself, the CCL will face this.
Yes.
Next.
Great.
My lord, my lord, 307, 326, and my lord, 25 of the Arms Act. What happened, my lord? 34 days principal accused on bail, my lord. After rejection of my anticipatory bail, next day I surrendered before the court below. I was taken into police custody. Nothing recovered. The gun was firearm was recovered from a field.
You fired.
No fire. Mat diye mereche.
Then 25?
That is, my lord, the police, my lord, they recovered from a field, my lord, the arms.
Petitioner what means that the butt of the revolver.
The Deshi, my lord, the local made pipe gun.
That is the part of the firearm. Okay. Petitioner contends that he is in custody for 36 days. Victim was assaulted with the butt of the firearm. He prays for bail. And a lawyer for the state opposes the bail prayer. We have considered the materials on record. Miscreants did not fire at the victim. They assaulted with the butt of the firearm, which improbabilizes a case of attempt to murder. Under such circumstances, and as there is no chance of abscondence, we are inclined to grant. Next.
My lord, 23, I am for the petitioner. My lord, initially case under section 307, subsequently 302 was added. My lord, in this case, the incident is of 9/7/2023. My lord, no contemporaneous complaints was there. First, FIR gets it.
Murdered a witness. We will not.
No, my lord, I am not even accused in that case. My lord, will
You
kindly.
may not be an accused in that.
My lord, will bear with me for one moment. My lord, 9/7/2003 is the incident. 7/8/2003 is the FIR is registered after 28 days. My lord, the allegation in the FIR is that some people uprooted a tree over which the deceased had lodged a complaint, and those accused persons came and assaulted the deceased. My lord, this is the contents of it. My lord, the FIR which has been referred therein, I am not even an accused person there. And my lord will see the FIR, my lord, in the length and breadth of the FIR, my name doesn't transpire. In the later portion of the FIR, 18 names has been given. There my name suddenly
We
transpired.
have rejected Sukamal Bhuiya.
My lord, that person's name was there in the FIR itself. My lord will see my involvement with that person's involvement.
What is
Lordship,
his
kindly
involvement?
see the 161 statement, their name.
Sukamal Bhuiya is specifically named in the FIR. My lord, kindly see page 14.
Sukamal Bhuiya, Devkumar Bhuiya, Buddhadev Bhuiya, Abhijit Das, Ajit Das,
Ajit Kumar Malya, Ajit Malya.
Amol something. এছাড়া আরো অনেকে petitioner contends that allegations against him are general and omnibus. He is in custody for
211 days.
over 200 days. He has been falsely implicated. He prays for bail. And a lawyer for the state opposes the bail prayer. She contends bail prayer of Sukamal Bhuiya was turned down by this court in December 2023.
My lord, just one thing, my lord. In FIR, the FIR Sukamal Bhuiya name is specifically mentioned in the FIR.
Witnesses statement,
My lord.
we have considered the materials on record. Statements of eyewitnesses show petitioner and others had assaulted the victim. They have been specifically named by the eyewitnesses. In view of the aforesaid materials on record and gravity of offense, we are not inclined to grant bail at this stage. Next.
May it please your lordship, I'm for the petition. He is registered under section 498, 323, 498A, 302, 304. Your lordship takes the postmortem report.
Husband.
Yes, my lord, the husband. The postmortem report, my lord, opines, the doctor opines that it was suicide by hanging. Now, my lord, these petitioner and the in-laws had taken the deceased to the hospital also. My lord, I'm in custody for 186 days. My lord, charge sheet has been already submitted.
See the PM report, page 32, my lord.
Yes,
There are, my lord, multiple scratch marks over the body, my lord. My lord, even the knife was recovered on the instant of this, my lord, petitioner, my lord.
PM
Page
report?
32, my lord.
How long you are in custody?
186 days.
My lord, eyewitness statement is also there, 11 years.
Page.
My lord, page 42. My lord, he was present inside the house, my lord. Page 42, my lord.
Petitioner contends that the victim lady had not been murdered. PM report shows she died due to antemortem hanging. He is in custody for
186 days.
86 days.
186.
186 days. Investigation is complete. Accordingly, he prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Statement of the witness, statement of the daughter or sister.
Daughter, my lord, they were
Sister.
sister.
Sister of the deceased.
No, my lord, he is the relative of the deceased, my lord.
This statement of the relative of the deceased shows that petitioner had assaulted his wife, that is the victim, and hung her with a ligature. Full stop. PM report shows presence of multiple injuries apart from the ligature mark. This corroborates the prosecution allegation of homicidal death. Under such circumstances and in view of gravity of offense, we are not inclined to grant it. Next. Yes.
Lord, this is
Give a copy. When?
Lord,
What?
Lord, this is arises out of SSC scam matter, my lord. This arises out of an SSC or on the as per the direction of this honorable court, my lord. FIRs were initiated by the CBI. This is RC6, wherein the present petitioner is involved. My lord, I gather, my lord, one of the co-accused matter is fixed on 11th. Kuntole, Sombar. 11th of this March. Kuntol Ghosh.
Here, I have to submit report.
A report be placed on record. Adjourned.
But may I come back at on 11th? My lord, because the co-accused bail prayer petition also is fixed on 11th
11th.
of
Give the
March.
number. Next.
Number. Kuntole order. Didich. I'm providing.
Next.
Didich. Kuntal Ghosh.
My lord, I am in custody since 22, my lord. Your lordship was pleased to reject it in 25th of November 22. My lord, 26 persons were named in the charge sheet. Out of them, 15 are on bail, 7 have absconded, 3 are in custody, and for one person, my lord, proclamation and attachment, it is still before the Chief Judicial Magistrate. And my lord, I stand on the same footing as the person who has been granted bail.
Who has been bailed?
Well, 50 of them, my lordship, I just give the names, my lord. I'll just give your lordship the names who have been granted bail. Ethitu dekhen. Alok Das and Anil.
Standing on same footing as that of Anil Chandra Das and Alok Das.
They were granted bail, my lord.
Rejected Mukesh Sarkar.
My lord had earlier rejected, and my lord my lord the 164 is one of the injured person. My lord, two persons were injured.
Rejected Mukesh Chandra Sarkar.
My lord had earlier rejected,
Then
and
No, my lord, then
many of them are absconding. My lord, till now, my lord, the charges.
but Anil Das, after your lordship rejected it, my lord, Anil Das and Alok Das were granted bail.
Where?
My lord, I've given the order sheet. If your lordship comes with the order sheets, my lord.
Yeah. At 22 to 20.
My lord, 22 to 24 and 26. My lord. And these two persons who were granted bail, my lord, firearms were recovered from them. Nothing from me. So, 500?
557.
My lord, in custody for 557 days. It is still before the CJM.
If the judge feels that judge can grant bail, we are not going to follow the judge. We have rejected.
But I have no comments on that. But the factum remains, my lord, it's still at the stage. We do not know when the trial is going to end.
Correct. That is another story.
No, I appreciate. My lord, I appreciate what is falling through your lordship's mind. Only thing, my lord, the CJM has not, he's waiting for the proclamation attachment order to come back.
We have said that 164 we don't know about others, but Mukesh, we have made a finding that they do not stand on the same footing.
At that time, my lord.
Then,
No, my lord, I'll tell lordship 164. If your lordship sees the 164 of the person, my lord, please seize that, my lord. Then maybe, my lord, that was not brought to your lordship notice at that time.
he said statement of injured eyewitness implicates the petition.
Yes, my lord. That is the statement.
My lord, seize the statement yourself, my lord.
Yes.
Please seize the statement.
My lord finds it illegible. My lord, I've got another copy.
My lord, I've got a handwritten copy, my lord, you can read this one. I take to thee, thou, my lord. And my lord, after your lordship rejected it, 14 months have passed by, my lord. No improvement, no. No, I get your lordship, but I have not, what I do about it, my lord. I've been given this copy, my lord. Specific allegation against Sanjit Das. Like that.
মুকেশ গৌতম মিলে ধরে মারধর করতে লাগলো।
But only to that extent, my lord. Nothing more, nothing less.
নেপাল অস্ত্র দিয়ে মেরে
Nepal is on bail, my lord.
অনিল ও তার ছেলে এসে
On bail, my lord.
হ্যাঁ
They are on bail, my lord.
ধান কপালে মারে।
And this 164 was after 3 months of the incident.
Onil has been given bail and
Anil and Orul.
Nepal.
And Anil, Alok and Anil and Nepal. And Nepal. And Nepal.
Alok is not named. Alok is not named. Nepal is named. Nepal and you stand exactly same.
Oh, same.
Anil and his son. His son is Alok. Huh?
Alok, yes, sir.
অনিকার ধান ভাঙানোর মেশিন দিয়ে কপালে মুকেশ মারধর সঞ্জিত
He is the person who is shot dead.
huh?
He is in custody.
He is the victim.
He is the main man.
No.
There are two injured persons. One is Sushant.
Malad, this is Sarkar.
Sanjit Sarkar. Sanjit Sarkar, Malad, died, succumbed to the
Injury and
Shanta is the statement.
Sushanta's statement is that.
Now Shumon is absconding. Let us see the postmortem report.
My lord, PM is page 132.
132.
So that's,
Bullet injury, no? Mara gেছে। Shot, no? Police.
Petitioner is in custody for
557 days.
557 days. He submits. There is no progress in the trial. Co-accused Anil Das, Alok Das, and Nepal. Nepal Das. Sarkar have been enlarged on bail. He renews his bail prayer. Learned lawyer for the state submit. Delay is due to abscondence of co-accused. We have considered the materials on record. Bail prayer statement of injured witness implicates the petitioner in the assault. However, co-accused Nepal Sardar Anil Das and his son Alok Das, similarly circumstanced with the petitioner, has been enlarged on bail. That apart, death was due to gunshot injuries and petitioner is not attributed with firing at the deceased, full stop. Whether he shared common intention with the co-accused who fired at the deceased may be assessed during trial, keeping in mind the extent of complicity of, keeping in mind the period of detention suffered by the petitioner and his role in the assault. We are inclined to enlarge him on.
Grateful, man. CGM Gongarampur. CGM Gongarampur.
Next.
I'm renewing my prayer for bail.
Yes.
Mother's pleasure would be to kindly come to the last rejection, which is happening in page 87. Page 87 is my rejection. That is happening on 1/6/21. Thereafter, my lord, on 21 to 24, I had filed this again. But your lordship comes to page 85, where a co-accused is being granted bail. And at that particular point of time, this learned court said that no, there was a difference for which the co-accused was being granted bail. The reason for granting of bail is in page 86, where it is stated that after meticulous examining such statements, we do not find any active role of the petitioner, nor he inflicted any blow on the deceased which led to his death. This was the ground on which the bail was granted. My lord, there are 80 witnesses. 10, the primary eyewitnesses have been examined. My lord, the eyewitnesses, your lordship would kindly see PW4 to PW7. PW4 being the father who had taken him to the hospital. At page 56, starts from page 56 at page 57. Page 57, 3 lines from the top. The witness pointed out towards accused Obijit and started saying that he caught hold of my son and dragged him outside. All 6 were hitting him mercilessly with sticks, rods, wickets, bricks, glass bottles. Obijit Roy then brought out the glass bottle from his pocket, broke it and struck the same on the right side of my son's name. Tarok also hit my son on the head with a glass bottle. Tarok and Obijit are the persons who are the persons for whom death has happened. Now, my lord's pleasure would be similarly, page 58, your lordship would see identified together Shontu, Obijit, and Moinuddin. You're all placed together effectively. Now, my lord's pleasure would be to kindly come to page 61.
Yes.
Where he contradicts. The witness contradicts so far as Obijit is concerned. Now, the other witness who's seen this,
For whom?
my lord, I am for Shontu.
So,
I am for
why
Shontu.
are you bothered about Obijit?
Now, page 65, PW5 at page 66.
Moinuddin is on bail.
Moinuddin is on bail.
Subroto is on bail.
No, Subroto, I don't know. Moinuddin is on bail, the only one which we know.
Moinuddin bail.
Yes. We've annexed that is the order sheet that I showed you, Your Lordship. Page 66. A tall person wearing a white shirt. This one, let me just please this. A tall person wearing white shirt pulled out my brother. Thereafter, Dholu, Taruk, and 4 other persons started hitting my brother with iron rods, bricks, glass bottles, wickets. Dholu and Taruk threatened us with dire consequences if we ventured out. When my brother tried to stand up, the man in white shirt broke the glass bottle and struck the same on the right side of the bar. Taruk also hit. And then he identifies him as Obijit. Same story. I will not repeat, my lord. It's PW6 and PW7. All of them have said that the primary assailant happened to be Obijit and Taruk, not me. I am standing on the same footing as that of Moinuddin.
So far as Moinuddin's bail prayer is concerned, Your Lordship will kindly come to page 85. What is the observation of the coordinate bench? 85 last paragraph. He doesn't stand on the same footing as of Moinuddin. Differentiation has been made by that bench only.
That was pre-evidence.
My lord, he is not a resident of that locality.
Approval has been examined.
Yes, number 1. And I have annexed
He
it.
is not a resident
PW1.
of the locality. The incident takes place at the dead hours of the night. It is
Page 41.
He just now placed that the victim made a dying declaration or whatever it is. Last statement is that they have come to take revenge.
No dying declaration, my lord.
That is the statement you just read.
No, I
You just read page 66.
Page 66
When
was all.
they were traveling together, had drinks, went in front of the house of the victim.
Mr. Roy,
Lordship.
the approval has been examined.
Yes.
PW1.
Yes.
Has he shifted from his earlier statement?
No,
Page
not
40.
at all.
Page 42.
We don't want you to lecture or
Well, I'm sorry.
intervene.
I'm sorry.
He has been seen in the videograph along with these boys.
No, we want to see the statement of the approval. If there is no departure, then
main statement.
we will not revisit the issue.
Page 66.
No, page 66.
Page 42.
Page 42.
41.
41.
41. No, that is the evidence, right?
That's right.
We are trying to find out what is the earlier statement of the approval.
164 about. দেখাই যে ওই বলছে ডাইং ডিক্লারেশন না
57. Page 57. আর দেওয়া আছে।
42 দেখাচ্ছিল না
164 of the approval.
So page 42, page 41 onwards, which is আমার approval.
এটা আমার ভাই বললো ওরা রিভেঞ্জ নিতে এসছে।
হ্যাঁ হ্যাঁ
তো কোথায়
সেটা তোমার 65 on না না page 56 page 56
এইখানটা দেখুন
My son told me that for us they have come to take revenge in the dying declaration.
57 টা মেন এখানে 4 6 and 7 এই তিনটে দেখুন
The approver does not speak of Moinuddin.
yes
Approver does not speak of Moinuddin. Approver does not speak of Moinuddin. The other witnesses, they do.
The differentiation has been made by the
But
bench.
the point is, my lord, with respect, my lord, all the approvers of all the eyewitnesses, first of all, the approver is not on the spot. That's one argument that I have. Second is that all the eyewitnesses have said that Moinuddin and me, we played the same role. So far as 2 other persons have killed, there's no dispute regarding that. But at 80 witnesses, out of that 10 have been examined, 3.5, 3 years, 10 months in custody. 3 years, 10 months in custody. So if your lordship,
Petitioner is in custody for 3 years, 10 months. He submits, he stands on the same footing with co-accused Moinuddin, who has been enlarged on bail. He did not give the fatal blow. He renews, there is no possibility of trial concluding in near future. He renews the bail prayer. Learned public prosecutor opposes the bail prayer. He contends Moinuddin does not stand on the petitioner. He contends bail prayer of petitioner was rejected earlier by a coordinate bench of this court, distinguishing his role in the case from co-accused Moinuddin. Full stop. Evidence trial is in progress. We have considered the materials on record. Bail prayer of the petitioner, a coordinate bench of this court turned down the bail prayer of the petitioner on the score. Turned down the bail prayer of the petitioner holding he does not stand on the same footing with Moinuddin, who has not been named by the approver. PW1, approver has been examined as PW1. He named the petitioner. He has named the petitioner, but did not speak of the presence of Moinuddin. Approver is examined as PW1. He is the driver of the vehicle which the miscreants had used to come to the spot. He named the presence of the petitioner, but not Moinuddin. Learned counsel strenuously argues other eyewitnesses have implicated Moinuddin. Implicated Moinuddin. Their deposition is not corroborated by the approver, whereas petitioner's role vis-a-vis role coming from the eyewitnesses corroborates the approver's evidence. Petitioner is clearly petitioner stands on a more graver footing than the co-accused Moinuddin, who has been enlarged on bail. There are ample evidence to show petitioner was present and participated in the assault, resulting in death. Under such circumstances, we are not inclined to grant bail. Trial court is requested to expedite the trial.
Any particular time frame your lordship?
Go to the Supreme Court and get time frames. Next.
I prefer the petitioner. 306, 506 of the Indian Penal Code. Victim committed suicide. There is a delay of 28 days in lodging the FIR.
Dying declaration? Suicide?
Not there. No.
Who is she?
Well, I had a love affair with the
2 years love affair. Subsequently,
Victim is minor?
no, major.
Petitioner contents there is delay in lodging first information report. There was a romantic relationship between petitioner and the deceased. Out of depression, she committed suicide. He prays for bail. A lawyer for the state opposes the bail prayer. We have considered the materials on record. There was a romantic relationship between the parties. Petitioner refused to marry.
Yes.
As a result, victim committed suicide. Whether the petitioner had abated the suicide requires to be assessed during trial. Victim had not left behind any suicide note. Under such circumstances, and as there is no chance of abscondence, we are inclined to grant bail.
Grateful. No. PCG में रखो.
But I am for the petitioner. Case of 302. But I am renewing my prayer after 6 months. Lordship speaks about a dying declaration in the earlier of the rejection. But I have something to say about this dying declaration. Malad, I have. Malad,
You have considered the
Malad, it is not dying declaration.
Malad of the petitioner had been rejected earlier on merits.
Malad,
accordingly, offensive proof would attract mandatory life imprisonment. Hence, we are not inclined to grant bail. Next.
Lordship, I'm for the petitioner, Your Lordship. Your Lordship, I'm led by Mr. Shobhajit Chatterjee, Your Lordship. The petitioner, Your Lordship, is the co-accused in connection with the PS case number Thakurpur PS case number 371, Your Lordship. of 2022, 2020 to 2012, Your Lordship. Dated, Your Lordship, 7 September 2012. Your Lordship, under section 302, 394 and 34 of the Indian Penal Code, Your Lordship. Your Lordship, petitioner is in the custody for the period of, Your Lordship, 11 year, 5 months and 28 days, Your Lordship. No progress in trial, Your Lordship. 68 charge sheeted witness, Your Lordship. Out of 68, Your Lordship, only 36 witness has been examined, Your Lordship.
We are going to finish the
Madam, we
trial.
have examined 37 witnesses.
Kindly let's have a glance, Your Lordship, 1 year of trial, Your Lordship. 71, Your Lordship, page number in internal page.
Can see the delay that has been attributed, how the delay has been attributed. My lord, the magistrate, we have prayed for 294 in respect of the my lord, landed magistrate recorded 164. They said no, we would examine her. And she was posted at Port Blair. She was repeatedly sent summons. She did not came.
This is the imagination of your prosecutor.
No, my lord.
Does the magistrate require to physically come to give deposition?
But they
Is it necessary for the magistrate to physically come to give deposition? Why you did not pray for an examination through video linkage? Why should a person require to come from Port Blair to give deposition?
Since last 1 year, Your Lordship, no witness has been.
Now he has come by creating a delay of not less than 8 months to 1 year. This is the imagination of a prosecutor. The commitment for speedy trial.
Well, they said that they would cross. They would
So let them cross. If there is a video linkage, the cross-examination is stalled.
But my lord, we so far I have been told that my lord, the fingerprint expert, the police witnesses, and the my lord, TI parade magistrate.
You give us a report within which time you can.
Within 6 months, the IO is present. The IO is present. They said that we will rely only on.
Since last 1 year, Lordship, no witness has been examined, Lordship. Like, kindly have a glance in, Lordship.
More than 11
Page number
years.
71, Your Lordship.
He submits, there is slow progress in trial, he prays for bail. And a lawyer for state submit, there are ample evidence connecting the petitioner with the crime. Trial has substantially progressed. He assures the court that examination of witnesses shall be completed within 6 months. We have considered the materials on record. Offense involves murder, which attracts mandatory life imprisonment. There are ample evidence connecting the petitioner with the offense. Trial is at its how many witnesses examined?
37. We will not examine the rest.
37 witnesses have already been examined. Prosecution proposes to examine official witnesses within 6 months, subject to cooperation by defense and other systemic delays. Under such circumstances, we are of the opinion this is not a fit case to grant bail at this stage. We direct the trial court to ensure completion of trial at the earliest without granting unnecessary adjournment to either of the parties.
Your Lordship, since his father of the accused, Your Lordship, is a serious illness, Your Lordship. He got paralyzed, Your Lordship. So,
Please, my lord.
Prayer for prayer for reconsideration in a case under 302 of the Indian Penal Code. But I am in custody over 7 years, 6 months. Co-accused persons are on bail, but my lord, I am the main accused according to them.
Trial is not complete.
My lord, it's 10 witnesses examined out of 30.
Why trial is not complete?
They are taking time.
My lord, I have the order sheets. The witnesses did not turn up. Witness warrant issued by the court.
Where is your order sheet?
My order sheet, I will file my supplementary application.
Petition seeks bail on the ground of delay in trial. However, the bail petition is bereft of material particulars. Accordingly, the application for bail is not entertained, liberty to file afresh.
Well, can I take back the certified copy?
Certified copy be returned. Next.
I'm a fresh pet.
Well, renewal of my prayer, and your lordship rightly found out when it was rejected. Well, at page 7. Well, I'm 442 days in. Only reason, well, why I have come before your lordship is, well, it was not brought to your lordship notice, the charge sheet. Well, if your lordship comes to page 12. Page 12.
Yes, charge sheet.
Charge sheet, page 12. Well, your lordship sees item number 10. Item number 10,
Yes, what is it?
that the gun was recovered from two persons.
All right. One of them is the petitioner.
And one has been granted bail.
Very good.
Your Lordship sees 12, my lord.
We have considered the materials on
Item 12, my lord.
bail prayer of the petitioner was rejected on merits earlier. Full stop. There is no change in circumstances.
The bail was granted to that man, the other person from whom it was seized.
But apart from that, there are other.
Only thing, my lord,
He is standing on the different
footing.
he has been granted bail. From this person, the offending weapon was recovered. And
Either list shows recovery.
either list shows, but
two
there is a
persons.
164 statement of the person who was there on the spot with the victim. So he says that this is the person who shot the victim.
Well, only that answer that one. What I've said, well, only page 12, well, cease for yourself, man. Item 10.
Petitioner submits.
Page 10
He
to
is
that
in
now,
custody for over 400 days. Firearm was recovered from petitioner and co-accused. Co-accused is on bail. He renews his bail prayer. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Statement of eyewitness show petitioner had fired at the victim, resulting in his death. Under such circumstances, petitioner cannot claim parity with co-accused who has been enlarged on bail.
No, only one request. It has just been committed. So let there be a. Again, I have to come to your lordship.
12 is the date of
Next.
Grateful.
Next.
My lord, I am for the petition in this matter. My lord, this is a renewal, my lord. The case under section 417, 376, 6 POCSO, my lord. The age of the victim, my lord, now 21 years and petitioner 25 years. My lord, the FIR has been lodged because, my lord, he did not agree to marry with this girl. My lord, now, my lord, I am agree to marry with this girl, my lord.
What is our headache?
The petitioner, my lord. My lord, earlier I have been granted bail, my lord. And my lord, subsequently, my lord, after my release, my lord, I have been entangled in 2 other cases, my lord. That's why, my lord,
In several occasions, my lord, he did not appear before the learned.
my lord, I have been entangled.
Warrant of arrest was issued. and he
Issued,
was
my lord,
rearrested
subsequently I have been
January.
arrested, my lord. And today, well, I'm in court 70 days in custody, my lord. 3 other persons who have from who
Custody for
they are already granted bail, my lord.
He was on bail earlier. He could not appear before the trial court as he had been implicated in other cases. He prays for bail. Learned lawyer.
There were several occasions he did not.
He learned lawyer for the state submit. Petitioner had absconded and had to be rearrested. We have considered the materials on record. Conduct of the petitioner is not appreciable.
My lord, 3 other persons already.
However, he is in custody for a protracted period of time. Under such circumstances, we are of the opinion petitioner may be released on bail subject to strict conditions. Petitioner while on bail shall remain within Chachol police station and report to officer in charge Chachol once in a week on further. Next.
Thank you.
My lord, allegation under section 448, 376, 2F, my lord, both are married. Both are major, my lord. My lord, it was earlier rejected on my lord, January month.
January, my lord, it was rejected.
My lord, kindly see, my lord, 158 days customary, my lord, any condition, lordship. My lord, both are married, my lord.
What is the progress in the matter?
My lord, no progress, my lord.
It has been submitted in this case.
Petitioner is in custody for 158 days. He submits that there is No progress in the matter since rejection of bail by this court. State shall submit report with regard to the on the adjourned date, adjourned 2 weeks. Next. 2 weeks.
I'm for the petition. I'm for the statement. My lord, in this case, on 17th August 2020, the petitioner surrendered, and on that day, bail was granted. Thereafter, the Honorable Division Bench was pleased to cancel the bail, considering the gravity, nature, and gravity of the offence. Thereafter, he surrendered. Presently, he is in custody for my lord for 1 year, 2 months.
So gravity we are rejecting now.
No, 8 other co-accused who are on the similar footing are on bail, and learned court is vacant since
We have
November.
considered the materials on record. There is direct allegation. The witnesses state petitioner had assaulted the victim, resulting in his death. He does not stand on the same footing with co-accused who are on bail. Under offensive proved would attract mandatory life imprisonment. Under such circumstances, we are not inclined to grant it. Next.
My lord, I am for the petitioner. My lord, I am in custody. My lord, I am renewing my prayer for bail after 10th of June 2022. Page 11, my lord, this petitioner was a principal assailant. My lord, the other co-accused person who was granted bail, my lord, was not the principal.
We have considered the materials on record. Petitioner is the principal assailant. Due to his assault, victim died.
2 victims, my
lord. Multiple victims died. In view of the gravity of offense and incriminating materials on record, we are not inclined to grant bail at this.
My lord, only one prayer, my lord, if the trial can be.
My lord, out of 32, 18 has already been examined.
Trial be expedited.
Next.
Next.
It's a bail in connection.
Yes.
The conviction under section 302 of the Indian Penal Code might. But the petition, the appellate is in custody for more than minus 10 years.
The paper book is ready.
Paper book is ready.
Paper books have been ready. Why should we give you bail?
Signed declaration before the doctor. Earlier turned down. 2007.
We have considered the evidence on record. Victim housewife, victim lady made a dying declaration.
PW 13 and PW 20.
PW before?
13. PW
Before the doctor.
PW
Before the treating doctor, PW 13.
PW
Full
20.
stop. Before the treating doctor, no, not 13.
13, 20.
Well, there are two dying declarations.
PW 13, PW 20.
Before
PW 13 and PW 20 minus.
PW 13 and PW 20, in view of the aforesaid clinching evidence on record, and as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. Let the matter be added to the list for hearing.
Okay.
Next. Next.
My lord, 39, I'm for the petitioner, my lord. My lord, petitioner is in custody, my lord, for around 7 years. He has been sentenced to suffer, my lord, under section 489B for 10 years, my lord.
We have considered the evidence on record. We have considered the materials on record. Sentence is one of term imprisonment. Appellant has undergone more than half of the maximum sentence imposed on him. There is no possibility of the appeal being heard out in near future. Under such circumstances, we suspend the sentence. Next.
Admission to Korean.
Admission.
42 is my appeal. My lord, section 5 has not been filed. My lord, we will file. My lord,
51, my lord, my appeal, I filed for application for suspension of sentence, my lord.
Let him file section 5 first.
no, his appeal is separate one. Mine is
Mine
separate.
is
All are connected appeals.
Connected.
So we'll consider it after you file section 5.
Kindly make it up next week. My lord.
Adjourn 2 weeks.
As a 2 weeks.
Adjourn 2 weeks. Paper book is there.
No.
LCR is there.
My lord,
Sir, let the LCR be produced.
my lord, Milan Mukherjee is appearing, my lord.
So
My
what
lord,
can we
court
do?
pass over, my lord.
We are adjourning it for 2 weeks. Next. 45.
45, I'm for the appellate. I'm for the state.
But as it had fallen from your lordship's, my lord, page PW 10 only mentioned that the child should be kept with, the mother said that the child should be kept away from the in-laws. That is all. But the dying declaration part is not supported by PW10.
Not only 10, 4.
4. Yes, my lord.
4.
All of
4.
4, 6 and 8 dying declaration.
Supported. 4 and 10 did not support.
Yes, my lord. Yes.
Appellant submits that the prosecution has failed to prove the oral dying declaration beyond doubt. While PW 4 and 10, who were present when who were present at the spot, did not corroborate did not speak of the dying declaration. PW 6 and 8, relations of the deceased, stated that she made a dying declaration on the way to hospital. Appellant is in custody for
Your Lordship, 14 years. Till
14 years. Accordingly, he prays for bail. Learned lawyer for the state opposed the bail prayer. We have considered the evidence on record. Prosecution case is based on an oral dying declaration of the deceased. Oral dying declaration of the deceased. PW4 deposed, he came to the spot after the incident and accompanied the deceased to the hospital. PW10 also accompanied the deceased to the hospital. None of these witnesses claimed, now unlike PW6 and 8, none of these witnesses claimed that the victim made an oral dying declaration en route to the hospital. Prosecution case is a divided house. Prosecution is a divided house, and prosecution is a divided house. Appellant has made out a patent lacuna in the prosecution case. He is in custody for 14 years. Under such circumstances, we are inclined to suspend.
Deeply obliged.
Next.
Well, I am for the appellants, my lord. There are two appellants, conviction under 498A, 304B of the Indian Penal Code, my lord. The appellants before your lordship are the married sisters-in-law, and they were on.
About the others?
5 people were made to stand trial. 3 were acquitted of all the charges. These 2 are the married sisters-in-law. They were on.
What about the other appeal? Any other appeal?
No, madam. Huh? 5 people were made to stand trial. 3 have been acquitted, and these 2 appellants had been convicted, madam.
All right.
And they were on bail throughout the course of trial, madam.
But within 7 months from the date of marriage, and the appellant number 1, my lord, demanded 20,000 rupees when she was on her family way, my lord. During the termination of the pregnancy, she demanded 20,000 rupees. That is evidence is there, my lord. The sister, the mother, and everyone spoke about the specific role attributed by these 2 appellants.
They are the sisters-in-law. What about the husband?
Husband used to work in Dubai.
Dubai.
Asami na to.
No, Asami should have been acquitted.
Husband, mother-in-law, brother-in-law has been acquitted.
The father of the deceased, my lord, he has been examined as PW1. He states in his evidence that no demand was made from him. He came to know about the demand from PW2, who is Jumni Bibi. If your lordship kindly takes up the evidence of Jumni Bibi, it is at page 58 of my CRAN. Jumni Bibi. The marriage takes place on 1st of January 2012. Jumni Bibi says, 1 month after the marriage, after 1.5 months, one day, Nikhat, that's the deceased, telephoned me and stated that she intends to meet me. We met and she stated that she needs 20,000 urgently. She stated that Rabia and Salma demanded the said amount for the delivery of child of Rabia. It was one Wednesday, date and time not stated. But if the marriage is on 1st of January 2012, 1.5 months from there would be somewhere around February, mid-February. The incident happens on 1st of August 2012. No timeline mentioned. Now, if you
Alright.
kindly come to page
Appellant
59.
submits that the life link between torture over demand of dowry and the unfortunate death and the death of the victim lady has not been established. Appellants are the married sisters-in-law of the victim. They were on bail during trial and did not misuse their liberty. Accordingly, he prays for suspension of sentence. Learned lawyer for state submit. Appellants had demanded money, 20,000 from the deceased housewife. As a result, subsequently she suffered. Subsequently, she was tortured and subsequently she suffered burn injuries and died.
But on the same day, when she was ablaze, set fire on her, the father went to their house and Milord for a settlement. The father came back. Then the father was informed that she has suffered burn injury. Went to NRS hospital and found the daughter dead. One will kindly see 60 and 61. Page number 60 and 61.
Sixty and 61.
60 and 61.
PW1 though.
PW1, Malu.
BW3 is the mother. Nasrin Begum.
Malu would also kindly see in the FIR, PW. And the father in the FIR states that when he went to the daughter's house, he found the daughter suffering from depression. It is in the FIR. And he states he went at 2, tried to make a shalish, came back at 9:30. At about 10:15, received a phone call that Rabia, the victim had caught fire. And she was taken to the hospital by one of the accused, the brother-in-law Sonu. He had taken him to the hospital. And my lord, in his evidence, your lordship will see the timeline has been completely shifted. He says in the FIR, he claims that at about 2 p.m. he received a phone call. He went to the house, tried to arrange a shalish, came back at 9:30 at night. But in the evidence, if your lordship kindly sees at page 56, he states that he went there at 9:30 a.m. in the morning. 8:30 a.m. he came back at 10:30 a.m. and the incident is at 9:30 at night. He completely he contradicts his version in the FIR as to the time.
She suffered burn injuries and died. We have she was tortured and suffered burn injuries and died. Within 7 months of marriage.
7 months.
We have considered the evidence on record. PW2 claimed that appellants had demanded money for the delivery of child
of the appellant number 1.
Of appellant number 1. There is no evidence that appellant number 1 was in the family at the material point of time. Full stop. It is to be decided in the course of hearing of the appeal whether the live link between alleged torture over demand of dowry and the unfortunate and the death of the house and the death due to burns of the housewife has been established. Sentence is one of term imprisonment. Appellants were on bail during trial and did not misuse their liberty in any manner whatsoever. Under such circumstances and in view of the law declared in Bhagwan Shinde Gosai, we are inclined to suspend the sentence.
Deeply replacement.
Yes. Next matter.
Lord, I am for the petitioner, madam. I am for the state. My lord, your lordship was kind enough to grant bail in favor of the petitioner on 31st of October 2022, my lord, on the condition that he shall appear before the investigating officer once in a week, my lord, and he would not enter the Bahrampur police station.
Investigating officer once in a week?
My lord, concerned police station, my lord. My lord,
Concerned police station?
My lord, where he is residing, my lord.
Where is he residing?
Beldanga police station, my lord.
Is he complying with the condition? Report be filed adjourned 2 weeks. Next.
Grateful, man.
Lord, I am appearing for the NIA. Kindly extend me time till 19th. I will file the report.
Report be filed adjourned 3 weeks.
My lord.
Was earlier granted 2 weeks.
Yes, my lord.
Now he's paying for another week. 2 weeks was granted by your lordship. Now this is
Till 19th, my lord. On 19th.
Adjourn 1 week. Next.
Lordship the imposed the condition that the petitioner shall remain within the jurisdiction of Baranagar police station. That has been waived. And another condition that he will attend the concerned police station once in a week. So this is the subject matter before your file the report.
Report be filed adjourned 3 weeks.
And Lordship, one thing, Lordship, the passport has been seized, which has been left, Lordship, for renewal of the passport.
My lord, I am for the petition. I
I'm for the statement.
My lord, order was passed 13/7/2023. I am just only modifying to condition the local security. He is not unable to.
Petitioner unable to arrange local surety, hence he is in custody, registered surety. Next.
Highly obliged.
কি বললেন?
Registered security body.
আচ্ছা এটা একটু নিয়ে নেবেন?
Highly obliged.
এটা একটু নিয়ে নেবেন?
For the statement.
Nobody appears. The petitioner has complied with the condition of bail. Accordingly, condition of bail. Where is he staying? Not to enter Tomluk police station until further orders and report to officer in charge of Chagotdigi police station within whose jurisdiction he is presently residing once in a week are waived. He shall meet officer in charge Tomluk police station once in a month until further orders. Next. Has he complied?
Complied, but my lord, where he is staying, that is not there.
Report is placed on record. Adjourn 1 week. Next.
Please, my lord. Well, this is a relaxation application. But this was hard other day. My lord, the papers were not in order. My lord, I have prepared a compilation for my lords. My lord, all these documents, my application, the state report, my first rejoinder, the second rejoinder. My lord, it's in a paper book form. It is in letter. Not to enter the Horishandrapur police station, my lord, where the lady is not residing.
Who are the witnesses?
161 statement. This is the order. Nobody has given any 161 statement, Lordship.
Yeah, that is what we are saying. Then petitioner contends that petitioner prays for relaxation of the condition of bail imposed on him, that is
page 8, paragraph 5.
That is not to enter Horishandrapur police station and to report to officer in charge of which police station?
Rathua police station. my lord.
Rathua police station, where he is presently residing once in a week. In response to such prayer, report is placed on record stating that petitioner had violated the conditions of bail and had entered Horishchandrapur police station. This is also supported by learned lawyer for
De facto
the
complaint.
de facto complaint. We have, he had, we have considered the report. We have considered the objection raised by the state as well as the de facto complainant. In the report filed by the state, it is claimed petitioner was seen moving around Horishchandrapur police station, within Horishchandrapur police station. In spite of queries, state is unable to place on record statement of any witness who had seen the petitioner move around, move within, seen the petitioner within Horishchandrapur police station. The complaint lodged by the de facto complainant with regard to violation of condition is also bereft, is also vague and omnibus. It is bereft with regard to exact date or time on which threats were held out to him. Under such circumstances, we are of the opinion the objections raised on behalf of the state and the de facto complainant are not supported by material evidence. Accordingly, we hold petitioner has duly complied. On the other hand, petitioner has placed on record his attendance to attendance before officer in charge Rotua police station regularly. Hence, we are of the opinion petitioner has complied with the conditions of bail imposed upon him. Full stop. Under such circumstances, we waive the aforesaid conditions of bail, but we direct the petitioner to meet the officer in charge, Tomluk police station. Once, Horishchandrapur. Once in a month until further orders.
Already one thing in my GD, my lord, I have not stated that they are threatening. I've just stated that they have violated and we are apprehending.
Sorry. Allegation of violation is bereft of material part. Next.
Grateful.
And
54.
My lord, the state has filed an application for cancellation, my lord. Your lordship is pleased to direct the accused opposite party.
I'm for the de facto.
You're for?
I'm for the de facto complaint, my lord. So there was a previous direction by this honorable court not to enter the jurisdiction. My lord, he's residing there only, my lord. That is my instruction. Apart
Where is opposite party? Who is appearing for opposite?
Mr. Datta Gupta.
You give notice to Mr. Datta Gupta. Opposite party accused is unrepresented. Report is placed on record. Matter will appear 2 weeks hence. Notice be given to learned counsel representing the accused. State is directed. Next.
I am for the petitioner, my lord. Mr. Shopon Banerjee is appearing for the state, my lord. May I see?
Nobody appears for the state. Petitioner is represented by his lawyer. Nobody appears for the state. Adjourned 4 weeks.
4 weeks.
4 weeks. Next.
4 weeks.
CBI 56, 57.
I am filing the report.
I'm for the
honorable Apex Court.
proceedings are pending. Proceedings have been stayed by the Honorable Apex Court. Accordingly, let this matter appear 8 weeks hence. Report be filed on the adjourned date. Further report be filed on. Next. 58.
Now I am for the opposite party number 2, man.
Deeply.
Nobody appears for the petitioner, so and so appears for opposite party number 2. Ms. Khan for state, adjourned 4 weeks. Next.
I am for the first.
Well, I am for the private opposition.
This is my affidavit of service.
Which is 59?
Yes, 59.
Well, I intend to use an opposition.
Oh, you are appearing first time?
First time
For
for
affidavit in opposition be filed 6 weeks, reply 8 weeks, matter will appear 9 weeks hence.
I'm deeply.
Next.
I'm deeply.
60.
The advocate appearing on behalf of the petitioner, he is out of station due to his father's funeral. Kindly grant 2 weeks.
On the prayer of the petitioner, adjourn 4 weeks. Next. 61.
61, my lord, I am for the petitioner, my lord, pursuant to my lord's order, my lord, I have paused service, my lord, but it was returned back as insufficient address, my lord. May I file the affidavit of service?
Affidavit of service is placed on record. Officer in charge, Dom police station shall notify opposite party number 2 to 5 with regard to pendency of proceeding and next date of hearing. Matter will appear 4 weeks hence.
Grateful, my lord.
62. Nobody appears, adjourn 4 weeks. 63.
In this matter, I beg to appear on behalf of the opposite party number 2.
So and so appears on behalf of opposite party number 2. Petitioner is unrepresented. You are for petitioner?
I'm for the petitioner, affidavit on service, your lordship.
All right, file your affidavit.
Affidavit in opposition.
Affidavit in opposition is placed on record. Ms. Khan is requested to appear on behalf of the state and produce case diary. Matter will appear 4 weeks hence. Affidavit in reply, if any, be filed within by the urgent date. Next.
I'm good.
I'm grateful.
Copy দিয়ে দিয়েছি তো আপনাদের।
হলো না?
64.
Copy.
Nobody appears. Adjourn 4 weeks. 65.
For the petitioner, I am pleading for order of service, my lord.
Huh?
I am pleading for order of service.
Order of service.
This is cancellation of bill, my lord.
All right. Copy of the application be served upon opposite party number 1 through public prosecutor. You go and appear, make your application before the magistrate. Why are you opposing why are you seeking cancellation?
Opposite party number 2 to 4. Filed an application, my lord, under section 430 of the RPC.
So they are threatening you. Then you go before the magistrate. Bail was granted. Petitioner has challenged bail granted by the magistrate. He contends opposite party number 2 to 4 are threatening him and others. In view of the nature of grievance, and in light of nature of grievance, we give liberty to the petitioner to agitate this issue before the magistrate. With this observation, application is disposed of. In the event the petitioner approaches the learned magistrate for cancellation of bail, the said magistrate shall consider such prayer in accordance with utmost expedition,
my lord,
and in accordance with law.
My lord, Landev's distinct session judge, my lord, was pleased to reject the prayer for anticipated bail of the opposite parties number 2 to 4 after going through the case diary and injury report, my lord. And thereafter, on 6/3/2023, the opposite parties were surrendered and prayer for bail was made before the landed additional chief judicial magistrate.
All right, কেটে দাও তো notice করো. Notice upon opposite party number 1 through public prosecutor, 2 to 4 through register speed post with acknowledgement. Adjourn for 6 weeks.
Yes,
yes. Yes.
66 আমাদের কোনটা 66 আমাদের 66
Yes, Mr.
There are 2 appeals to be heard.
Yes.
I don't know why is the other
No lawyer appearing for
Kaushik Chaudhary is appearing for
inform Kaushik Chaudhary. Inform Kaushik Chaudhary, right?
Today it will be taken or
we will sit up to 2:30.
2:30.
The Supreme Court admins to
I'm
be
informing
there.
Court.
So,
Because my lord, 3 months time has been given by the Supreme Court to dispose of the appeal. That is on 9th January. So it is till 8th April. 3 months will expire on 8th April. So my lord, we have taken up an order. That is the order, my lord.
No, we have thrown the order to you.
will this direction survive after the Constitution Bench decision of the Supreme Court?
But the Supreme Court direction.
That is why we are saying the larger bench of the Supreme Court says that there cannot be a time frame before it. So we will dispose it of. Mr. Basu, what are the points on which you are?
But I'm telling you now. Non-compliance with 42(1), 42(2), 52A, and so for this appellant is concerned, his implication is based on the statement of the co-accused. Nothing was recovered from.
Oh, so far as he is concerned, co-accused.
Sorry.
Only co-accused.
Only. So far I am concerned, only co-accused. Nothing.
But material exhibit 1, my lord, says that is a pocket diary. That pocket diary, my lord, totally indicating the nexus between the appellant number 1 and appellant number 2, the login dash and that's why, my lord, the earlier bench, when the matter was taken up, my lord, the earlier bench called for the, my lord, the material exhibit 1. That was not in there. And my lord, we have
Has the material exhibit come?
Huh?
Has the material exhibit?
No, my lord, that has come.
Not so far pocket diary is concerned, the evidence of the investigating officer is he did not obtain any expert's opinion with regard to the handwriting. This is the evidence of the investigating officer. He knows it.
But Mr. Basu, please go through the. Have you gone through the pocket diary?
No, not yet, my lord.
Please go through the pocket diary. What is the entry in the pocket diary? That has to be seen, right?
Very well.
So please go through the pocket diary. Heard Mr. Basu for the appellant. Let this matter appear again on Monday for further hearing. Please examine Mr. Bordon and Mr. Basu will ask your junior to examine the pocket diary as to what is the evidence will not do, isn't it? The material exhibit, entries in the material exhibit is what is relied on. So what is the nature of entries? Secondly, are these entries put to the accused on the 313? Isn't it? If let us say 2,000 rupees for narcotics to Mr. X, then that entry must be marked and put to the accused for his explanation under 313. Otherwise, you cannot, just because you have seized a pocket diary, Mr. Bordon, you cannot use the contents of the pocket diary.
And leading statement to recover 196 bottle also was recovered, but
not from him.
No, from others,
other will come later.
1,000 bottles of fentanyl.
From him, 196 bottles.
From leading statement, my lord.
All.
In that matter, acquittal. Yes. In that matter, he has earned an order of acquittal.
And in pocket diary yes. Mr. Bordon, more we choose to rely on you. Please become objective. As a prosecutor, you if you are going to become so nebulous, you will not assist the court.
The appellant has been acquitted. That instruction I have got.
First and foremost, is he charged for 196 recovery in this case? Then why are you bringing that evidence here?
His pocket.
Monday we are keeping.
It will be on second half, Monday. Monday on second half.
As soon as we finish our application.
But item number 64, cancellation of bill appearing for the first time, may I only serve copy upon the accused person?
Not today. Copy 6 weeks.
Grateful.
All right. Other matters tomorrow.